All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Catherine Carlson presiding.
Be seated. Morning. The case now at hand is file number WC246550, entitled Nicholas Rowe versus City Minneapolis Police Department. As you will see, we have a full 5-judge panel. We have Chief Judge Patty Millen, Judge Tom Christensen, Judge Deb Sundquist, Judge Sean Quinn, and myself, Judge Kathy Carlson. You have both been here before, actually fairly recently. Your experienced counsel, but I will remind you of the timing rules. You each have 15 minutes. The appellant will go first. You are allowed to reserve as much time as you want for rebuttal. You need to keep track of the time yourself. When you sit down, the marshal will make sure that you have that amount left on your clock. If we have questions that go beyond the time, that's fine. Otherwise, we'll be holding it to 15 minutes. Also, so that you are aware, we are both recording and live streaming this. So you both do a nice job of speaking up, but just remember that you are being live streamed. Ms. Bierman, you represent the appellant. You may begin.
May it please the court, counsel. Good morning. My name is Ashley Bierman, and I represent the appellant, Nicholas Rowe, in this matter. I would like to try and save 2 minutes for rebuttal, and I'll be looking at the clock in order to do that. Primarily, what we're here today to discuss is the issue of PTSD and how it must be diagnosed under Minnesota Statute Section 176.011, Subdivision 15D. Today, we're going to be asking the court to reverse the December 22nd, 2023 findings and order of Judge William Marshall, find that Minneapolis did not rebut the statutory presumption by substantial factors, and award benefits to the employee for the relevant time periods. Specifically, we're going to ask that the findings and order be reversed because the opinion of Minneapolis's expert, Dr. Young, was legally deficient. Dr. Young did not evaluate the employees for PTSD using the most recent version of the DSM, and therefore the compensation judge could not rely on the opinion of Dr. Young in making the determination in this case. And the compensation judge is finding that Minneapolis established substantial factors to rebut the statutory presumption of work-related PTSD in this case was clearly erroneous and unsupported in view of the record as a whole. I'm going to start by diving into the first of those issues first, and that is related to the version of the DSM utilized by the defense expert in this case, Dr. Young. The plain language of Minnesota Statutes 176.011 Subdivision D requires that evaluators, licensed psychologists, rely on the most recently published version of the DSM when assessing an employee for post-traumatic stress disorder. There were 2 experts in this case, Dr. Alec Novichus and Dr. Young. Both experts testified at hearing that the DSM-5 TR was published on March 18th, 2022. Minneapolis's expert, Dr. Young, evaluated the employee on November 3rd, 2022. This is approximately 8 months after the DSM-5 TR was published by the American Psychological Association. There's no question that at the time of Dr. Young's evaluation of Mr. Rowe, that the most recently published version of the DSM was the DSM-5 TR.
Ms. Bierman, I'm going to just pause you for a second. We've all read the transcript, including the expert testimony from both of the witnesses and their explanation as to the TR and how it was or was not important. Let me ask you this. Do you feel that it's a technicality, or do you feel like there was real substance in the TR that somehow changes the description of the condition of PTSD?
Thank you, Your Honor. I do believe that there is a real substantive change between the DSM-5 and the DSM-5 TR. And I would point you to Dr. Alec Novichus's testimony in this regard, in addition to our quotes from the American Psychological Association indicating that there were substantive changes. The legislature did not refer to the diagnostic criteria contained in the most recent version of the DSM. They referred to the most recent version of the DSM. So we as lawyers, I don't feel are in the place where we can argue about what's a substantive change and what's not. The legislature told us what we have to do in order to diagnose PTSD. And the long and short of it is that was not done by Minneapolis's expert, in this case, Dr. Young.
But, you know, I don't know if he got this technical, but didn't Dr. Young essentially say there are no substantive changes? And so could the compensation judge just say, well, I'm relying upon no substantive changes in the TR?
Dr. Young testified that there were no changes in the diagnostic criteria between the DSM-5 and the DSM-5 TR.
And there's no dispute about that.
There is no dispute about that, Your Honor. Dr. Aleknavichus also has indicated that in her testimony. But what he does acknowledge is that there were changes to the text. He refers to it as the text revision, and he does acknowledge that there were changes there. Now, he might disagree as to the nature and extent of those changes and how much this affects this case. However, we didn't get there. He did not evaluate this employee, Mr. Rowe, using the DSM-5 TR. And that's the issue here. That opinion is legally deficient. He did not use the correct version of the DSM, even though he had ample time to do so.
And I have a question regarding both experts diagnosed Mr. Rowe with alcohol use disorder. Both used the CAPS 30-day review backward in time. Am I correct in that?
I believe so, Your Honor. I know both experts did utilize the CAPS 5 30-day version. I would have to check Dr. Aleknavich's second report if she also utilized the worst month version, but I do know that she used the 30-day version in both of her evaluations and that Dr. Young also used that.
Thank you. But my question is, assuming they just use the 30-day version, and when you diagnose the alcohol use disorder, is that also just going back 30 days? Because in looking at the report of Dr. Young, he goes back, 20 plus years in terms of alcohol use by Mr. Rowe over that period of time, back into college, back into a Halloween party and things of that kind. And my question is, from your perspective, would that have been better using the worst month or over a longer period of time? Or is it this 30 days that I'm only supposed to look at?
Thank you, Your Honor. I think I understand the question. So for post-traumatic stress disorder, the CAPS 5 is the gold standard in diagnosing PTSD. The CAPS 5 is not utilized to diagnose things such as alcohol use disorder, but I do think that Dr. Young should have used the worst month version of the CAPS 5 to evaluate whether Mr. Rowe had post-traumatic stress disorder when his symptoms were the worst. So likely when he left law enforcement in March of 2022. He did not do that. I don't believe that Dr. Young interviewed Mr. Rowe with enough detail to determine whether he had alcohol use disorder at any point before his evaluation, which took place in November of 2023, I believe. And Your Honors, this brings me back to my point here. Dr. Young failed to rely on or even cite to the DSM-5 TR in his psychological evaluation report. He also admitted during cross-examination that he did not rely on the DSM-5 TR in forming his opinions in this case. The analysis should end there. Dr. Young's opinion is legally deficient and should not have been relied on by the compensation judge. To hold otherwise would circumvent the legislature in the plain language of Minnesota Statute 176.011 subdivision 15D. I would also point out that there is established case law on this point in a footnote in Hers v. Mower County, in addition to a reference in T v. Ramsey County from this court. The Minnesota Supreme Court in Hers noted in the first footnote that it could not rely on an expert presented by the employee in that case because the record did not reflect that the expert ever used the DSM-5 in diagnosing the employee. At that time, the DSM-5 was the most recent version of the DSM. In that case, the Minnesota Supreme Court said, hey, I can't rely on this expert. There's no evidence that this expert relied on the DSM in forming this opinion. They did not even summarize that expert's opinion in the Supreme Court's opinion.
Well, Ms. Beamer, I'm going to interrupt you a minute, and this has to do with your initial argument of what you're seeking, reversal. So assume that this court does reverse the finding that the employer met the rebuttable presumption, and it goes up, and they find that that finding was not manifestly contrary to the law. What do you do with all the other issues that were never addressed? Do we remand those for a continued determination to analyze? There's a lot here that wasn't addressed. It was dismissive with a finding that the employer had met the presumption to rebut, correct?
Correct, Your Honor.
What do we do with all the other issues that weren't addressed?
And that's a good question. I would say reversal is what is appropriate here because without Dr. Young's report, it's irrefutable that Mr. Rowe met the statutory presumption, and Dr. Young's report is the only factor that was cited by the compensation judge that was a substantial factor to rebut that presumption. So I think reversal is appropriate here. However, in terms of your question, Your Honor, in terms of what happens next, I do think there would have to be a remand with regard to the other issues in this case. There were a lot of other issues in this case, absolutely. One of them being penalties for frivolous denial, and frankly, many other issues that Minneapolis, I'm sure, would like addressed for defenses in this case, such as, job search, MMI, et cetera. So I do think a remand would be appropriate as to those issues, Your Honor.
Thank you.
Because the PTSD presumption was met in this case, irrefutably, and because, as I mentioned, Dr. Young's report is the only evidence that was presented by Minneapolis to rebut the presumption, the findings in order, and specifically the finding regarding the rebuttable presumption, in my opinion, must be reversed. Now, if this court decides that I'm completely incorrect and reversal is not what will happen here, I would argue that also that work comp benefits should at the very least be awarded from the period of time when the presumption attached, which was March 3rd, 2022, the date of Dr. Alec Novichus's report, through the date that Dr. Young issued his report, which was November 17th, 2022. Prior to that report, November 17th of 2022, substantial factors did not exist to rebut that presumption. And that's based on other important factors here. During the testimony, during cross-examination, Dr. Young admitted that Dr. Alec Novichus would have been in a better position to evaluate Mr. Rowe on the date of her evaluation, which would have been back in March 2022. He's not saying that he was in a better position to know whether Mr. Rowe had PTSD at that time or not.
But he still disagreed with her. And he said, he's never had it. Does that rebut it all the way back to the beginning or not?
I don't think so, Your Honor. I agree that he did state that at multiple points, but Dr. Young also agreed that Dr. Alec Novichus would have been in a better position to evaluate that. So I do think that that does not get to the standard of overcoming the presumption in this case. I also would point out that this case has some similarities to Juntinen. Both use the CAPS 5 30-day version, both experts. And so Dr. Young in this case is focusing his analysis on the 30 days preceding his evaluation of Mr. Rowe. He does not specifically say that he knows better than Dr. Alec Novichus as to whether Mr. Rowe had post-traumatic stress disorder at the time of her evaluation, which was in March of 2022.
But he disagreed with her application of the CAPS 5 and how she came to it. So, you're right. He did say that. She's in a better position. Despite that, I still disagree with her is kind of, what he said.
Well, and Ms. Pearman, speaking of Juntinens, and so in Juntinen, and they were, the Juntinen court was citing a case, Jurabek. It said the presumption may be rebutted by substantial factors. If rebutted by the employer, the presumption disappears. So does it mean disappear the day of the report, or like it never existed and then your client wouldn't be awarded those months of benefits?
I think it depends on the time period in which we're speaking about. That's how I interpreted that, Your Honor. So the presumption disappears as of the date that that presumption was rebutted. And so in this case, this presumption was not rebutted and cannot even be argued that it was rebutted because no evidence was produced to rebut that until that November 17th report from Dr. Young.
But once it's rebutted and it disappears means it's like it never existed. So does he still get that period of a PTSD diagnosis if that PTSD diagnosis then disappears?
I think that that would be the case if the compensation judge or even Dr. Young argued that the initial diagnosis wasn't credible or wasn't based on adequate foundation. We don't have those findings here, Your Honor. The compensation judge actually implicitly at least acknowledged the fact that Dr. Aleknovich's diagnosis was credible because he said the presumption applied. If there was not a credible diagnosis here, the presumption would have never applied. And so because there was a credible diagnosis made, I do believe that the employee would be entitled to benefits through the date that the presumption was rebutted here, which would have been the date of Dr. Young's report. I have 30
Do you know
seconds.
any other area of law where you could do that analysis in workers' comp within the statute?
Offhand, Your Honor, I don't. I'm trying to think of how the cancer presumption is treated, and I guess I don't have enough of those cases to know whether it would be applied in that way, but I think it could be argued that it should be. So I don't have a good answer for you on that one. I would look to perhaps how the cancer presumption is applied. I think it's similar, but I don't know that I have enough of those cases in my personal repertoire to comment in a reliable way to the court.
Ms. Spearman, I know you wanted to save some time. I can tell you that if we have questions, we will ask you to come back up. But you do have about 30 seconds left, I think, if you want to save that.
The last thing that I want to cover just briefly, Your Honor, is the fact that I do think that the
Well,
findings.
and I'm sorry, you are out of time right now. What I'm saying is I know you wanted to save some time, so if we have questions, we'll ask you to come back up.
Thank you,
Okay,
Your Honor.
thanks. Proceed.
Good morning. My name is Anthony Gabor. I'm here representing the city of Minneapolis in this case. May it please the court, counsel. The criteria in the DSM-5 and the DSM-5-TR are identical. That has now actually been recognized by the Minnesota Supreme Court in a recently decided T case at 5 Northwest 3rd, 114. It's note number 4. They do not make any rulings regarding the criteria. They simply acknowledge in a footnote that they are identical. Now, what's interesting is there's been this discussion of the fact that Dr. Young used the DSM-5 in November of 22 and Dr. Aleknovich's used DSM-5-TR. The CAPS-5, which is used to analyze the DSM-5 criteria, was used by Dr. Aleknovich's both times. If you look at both of her reports, she used the CAPS-5 for the DSM-5.
Counsel, I read footnote 4 of the T decision by the Minnesota Supreme Court a little differently. The last sentence says, for these reasons, the issue of whether the correct version of DSM was used is not before us.
Right.
And we, at the Court of Appeals level, had determined that it was forfeited. So a forfeiture of an issue and an issue not before the Supreme Court is not a determination, in my mind.
It isn't.
That it's a distinction of a hyper-technicality without merit.
It's not a determination. It's, as I indicated in the footnote, it basically says the criteria are identical. And then we stop there. Because you're right, the rest of the footnote goes on to say exactly what you just recited. My point is that the Supreme Court has just acknowledged that the criteria in both versions are identical. That's it. They don't go any further than that.
But Mr. Gabor, doesn't the statute doesn't say, based on the criteria set forth in the DSM, it says the condition as described. Would you agree that the condition as described in the DSM goes beyond just the criteria?
Well, Dr. Young testified that obviously text revision, it's basically just an update of the research. And I think
Exactly, and isn't that why the legislature would have said the most recent version? So that it can encompass more recent research, it's an evolving diagnosis, it's an evolving condition. So wouldn't that make sense that the text revision that encompasses most recent research be considered by an expert?
yes, but if you look at what the text revision actually says, there really is no difference. Okay, the issue that in this case, and the issue in another case that's before you with both counsel here, the Peterson case, is this discussion in the TR about this lifetime diagnosis. Okay, that's the only text that has really been cited by Dr. Aleknaviches as being pertinent. And if you look at that text, it has no bearing here, because all the TR is saying is you can have a diagnosis of PTSD, and they call it lifetime PTSD, if you've met the criteria at some point in your life during the same month period of time. And what HERS tells us is, you can have PTSD in March of 2022 and be entitled to benefits. But in November of 22, if you're found to no longer have PTSD, you're not entitled to benefits anymore because you don't have the diagnosis. A very good example of this.
Let me stop you there. And isn't that the situation we have? And Ms. Bierman was asked that same question. Dr. A diagnosed in March 2022, Dr. Young in November of 22. And I'm just going to find out, ask you, isn't Mr. Rowe entitled to benefits during that period of time because the presumption wasn't rebutted until Dr. Young's report was issued?
Well, that goes to the question that you were just posing to Ms. Bierman, Judge. Once the presumption has been rebutted, as it was found to be in this case, you're right, the presumption disappears, and it is as if it never existed. Judge Carlson, you mentioned the Jerebeck case. If you look at that case, the case of Jensen versus Duluth is cited in that case. There's language, it's a 1964 Supreme Court case. There's language in it that clearly states it has to do with the heart presumption. I'm going to call it the heart-related issues, where if the presumption is rebutted, it disappears as if it never existed. That's pretty close to a verbatim quote.
All right, I'm going to give you a verbatim quote from Juntanen. And this was in Juntanen, and you're familiar with Juntanen, there was a concurrence, and the concurrence said, we're troubled by this because, a city is going to have to pay benefits before they get a chance to rebut the presumption, essentially something to that extent. But the statute says what it says, so we're concurring. And the majority in a footnote addressed that concern and said, municipal employers can also mitigate their financial exposure in these cases if a compensation judge decides that a competing diagnosis offered by the employer is more credible than the employee's offered diagnosis. The benefit period would be limited either to the date of the employer's diagnosis or earlier if the employer's expert opines the employee's history of opines on the employee's history of PTSD, which initially suggests you can't rebut it backwards, but then in the end kind of says it does. But then at the very next sentence, it talks about an employer can also limit its costs by ensuring the employee receives appropriate treatment in a timely fashion or a timely manner. So that suggests to me, employer, once you've got this diagnosis from the right kind of psychiatrist or psychologist for the right kind of employee, pay the benefits, provide the treatment, and try to get them better. In the meantime, go rebut it too. And then once you do, stop. I mean, can I interpret it that way?
The language is not as clear as it could be, Judge.
Sure.
And I guess I go back to what I said a moment ago. Juntanen also says, and I don't have the exact site that you have there, but it also says that the employer gets an opportunity to rebut the presumption. And as that rebuttal has been interpreted in the Jensen case and sort of in the Juntanen case, was what you're talking about is once it's rebutted, as it has been in this case, it's like it was never there. And so I would argue that Mr. Rowe is not entitled to benefits for that period between March and November because there was a rebuttal. And there was also, if you take a look at Dr. Young's report, he goes into great detail. You touched on it a little bit, Judge Quinn, when you said, you know, he disagrees with Dr. A because she misapplied the caps. That's important because that's an important diagnostic rule. Everybody agrees it's the gold standard for diagnosing PTSD according to the DSM-5. And so his interpretation or his opinion as to what was lacking in Dr. A's diagnosis, while she might have been temporally in the best position to diagnose him because she was there, he can look back and say, okay, you were there, so you saw him, he was in front of you. But if you misapply the tools that are used to diagnose it, then even if you're there, it doesn't mean that your diagnosis is credible. And there is no finding, as Mr. Rowe's counsel argued, that there's an implication that Dr. A's diagnosis was credible. The statute just requires a licensed psychologist to make the diagnosis, and the presumption applies. There's no determination of credibility. That, according to Juntanen, comes with as part of the rebuttal. You can rebut it by showing it was not credible or invalid, are the two options. So there is no implication of credibility just because the diagnosis is there. It's the fact, according to Juntanen, the fact that it was statutorily competent diagnosis triggers the presumption. End of story.
Let me say, I mean, I'm misunderstanding then Smith and what T said, because you're kind of doing what you're asking us and the compensation judge, put those reports up, look at the DSM, and then compare them and see if it meets the DSM. And we've been told by the Supreme Court that's not what we're supposed to do. Do you agree?
Well, I agreed up until a little less than a month ago when the T case came out, and the Supreme Court altered its guidance a little bit as to what compensation judges can do. Now compensation judges are allowed to look at, according to the Supreme Court, they were always allowed, but that was not the interpretation, are allowed to look at the DSM and see if an expert's opinion comports with it, but it has to be in the form of the other expert's opinion on a particular issue. Okay, so a month ago I would have agreed with you, Judge, but today I would say compensation judges can look at the DSM in context of the expert reports and decide whose is more persuasive or credible. At the time this case was decided, though, that had not been clarified. And what Judge Marshall did here is he looked at both reports, he looked at the testimony and listened to the testimony. He was there. He was able to determine that Dr. Young's explanation and reports and testimony were more persuasive than Dr. A's. Dr. Aleknaviches. I tend to mispronounce her name, so I shorten it. My apologies.
We do
in
too.
case she's watching.
Yeah, it's the first time I heard it correctly pronounced today. So there you
I've
go.
been practicing and I have only recently got it correct.
Well, let me ask you about Dr. Young's report, though. He says, and more so his report, his diagnosis. He says, you know, Mr. Rowe suffers from alcoholism, you know, substance abuse disorder, alcohol addiction disorder, however it's actually characterized. And the actual evidence that we have is the employee testifying, I did some binge drinking in college, or pre-college, high school. I drank too much at social events, and then including this Halloween event in 2024 or 2004. And then, and this is Dr. Young's report, his drinking increased significantly in 2007, which was when the traumatic events started happening. There's also some testimony. My doctor told me to stop drinking, but we don't actually have that doctor report, so it's just his testimony. Dr. Young apparently reviewed records dating back to 2000, but he doesn't even cite what those records say. So we just have the employee's testimony. My doctor told me to stop drinking. And he took those couple of snippets and said, yeah, he's been an alcoholic since way back when. Is that enough to say you've been an alcoholic since way back when?
Well, I don't mean to parse language. He doesn't
No.
call him an alcoholic.
Well, and I don't mean to put labels either, right?
Right.
But I'm just using it for simplicity.
He does, and you know, part of Mr. Rowe's deposition transcript was attached to the reply brief here, so you can see what he testified to. And he testified under oath that his doctor back to 2003 or 2004 said, you need to stop drinking, you should stop drinking. And so,
But does that mean you got a problem? I mean, my doctor tells me that too, and I don't think I have a problem. Doctors don't like you drinking, generally.
well, with all due respect, doctors are probably in a better position than you or me or Mr. Rowe to determine whether they have a problem or not. I think more importantly than the labels, okay, of alcohol use disorder, which is the technical,
Right.
what Dr. Young opined, and I think what was persuasive to Judge Marshall was, and he characterized it as sort of a fog that comes over you. He talked about how PTSD symptoms are, you know, symptoms of PTSD can be replicated by the use of alcohol. Use of alcohol is a depressant. It can make you react to things differently if you're not using alcohol. It can cause depression. It can cause, I mean, if you go through Dr. Young's testimony, he talks about the similarities, and what he basically says is, sure, there can be comorbidity. Okay, that's been shown a lot, but unless and until you get rid of the alcohol use and the quantities that Mr. Rowe was drinking, you can't credibly make a PTSD diagnosis.
And let me stop you there. The only evidence that I've seen regarding Mr. Rowe's drinking and how much and how often comes from his testimony. I haven't seen it, and which is set out in Dr. Young's report, but I haven't seen any other. Can you point me to another record or something where somebody else has listed out what he said, or medical record report, Beth Jordan, somebody?
Not in the record, Your Honor. And I think a lot of times, I think the fact that it is found in two areas in the record where Mr. Rowe himself is talking about it is instructive and important, because one of the things that Dr. Young, I believe, says in this case is, you know, when you ask people about this kind of thing, they tend to minimize it, okay? And they tend to, here we have Mr. Rowe testifying under oath. Yeah, my doctor told me back in 2003 I needed to quit drinking.
Do you really think that's enough under criterion G to all of a sudden import this as the basis based on the evidence that we see in the record? I think Dr. Young carried that ball all the way to a finish line, and I'm not sure there was enough evidence in the record to sustain that analysis, especially since I was looking at the record as a misuse, use, or abuse. I just don't see how all of a sudden he could move to that defense as a criterion G and be so dismissive of any of those symptoms carrying forward into a PTSD claim, which would be then self-medicated, perhaps, by the use of alcohol. And again, to what degree, based on just the testimony, very limited, of a peace officer.
Well, Judge Millen, I think it is enough, okay? But even if I'm wrong and you're right, Mr. Rowe and Dr. Young talk about the fact that, I'm out of time, may I finish?
Go ahead and finish.
Yeah.
Okay. I think Dr. Young talks about the fact that in 2007, Mr. Rowe's drinking increased significantly, and everyone else says that too. And I think what's important to note about that is, even after his drinking increases significantly, that's 2007, he continued to work until, I believe, late 2021 or into 22. So that's 14 and a half years.
Right, so he
of
could just be a
increased-
high-functioning alcoholic, self-medicating because of the stressors and the psychosocial stressors of his job or otherwise.
Well, when you
We
say
don't really know, do we?
Well, you're right, we don't, because when you say self-medicating, Judge, we don't know that. You and I and anyone besides a psychologist or an alcohol use therapist doesn't know that. And so
Because I
that's
don't
why,
know if it's abuse, misuse, or what his use is. A high-functioning, a drink for somebody that has 3 or 4 in an evening, maybe in their minds, and to others a misuse. it may be characterized within the range of normal. Again, the evidence to sustain that movement into a criterion G and completely dismiss all those symptoms that led in his testimony to his self-medication. And you're right, I am using that loosely. I just don't see it in the record, and I'm confused why Dr. Young would feel so confident to carry that to the finish line as a reason for somebody that doesn't have the PTSD. I'm just lost in the evidence, and maybe you can point me to the evidence.
Well, Judge, I'll make 2 points. Number one, that's why Dr. Young is an expert. He's educated and studied in these things, and he gave a long explanation in the transcript as to why he thinks the alcohol overlay with PTSD symptoms is so difficult to decipher. And I think more importantly, from a legal perspective, Judge, the compensation judge here made a credibility determination regarding his persuasiveness, his reasoning. He talks about it in his memo. And respectfully, this court is constrained to take a look at the credibility determinations that the judge who was there and listened to the testimony made. And if there's evidence to support it, which I believe there's years of abuse of alcohol that Dr. Young says is prominent and is the primary diagnosis. And without removing it, you can't properly analyze whether somebody has a diagnosis of PTSD. And he's critical of Dr. A, who didn't seem to do very much analysis at all. If you look at her second report, at this point in time, her first report, she has virtually no records that she bases her opinions on.
Mr. Gabor,
Yes.
you've answered the question, and
I'm sorry.
No, that's fine. You're well beyond time. I just want to make sure that the judges have all of their questions answered.
I have one more question, same question I asked Ms. Bierman. Dr. Young used the CAPS 5 1 month or 30-day back. But then, as you suggested, going back and looking at the alcohol use disorder goes back, 20 plus years. And then testifies, or in his report, says the alcohol use disorder mimics some of the characteristics or criteria of the PTSD diagnosis. Should you use that same 30 days, or you're allowed to use any period of time?
In that respect, I agree with counsel, Ms. Bierman, that the CAPS 5 is used as a diagnostic tool for PTSD and not for alcohol use disorder. You saw in Dr. Young's report, he laid out the criteria for alcohol use disorder. So CAPS 5 is for PTSD and not for any other DSM-5 criteria or disorder, excuse me. So I guess to answer your question directly, it's okay that he went back, because I think you have to ask that question when you're interviewing somebody. How much are you drinking? The criteria was all there in his report. How much are you drinking? Do you have urges after, to drink? An example of that is, Mr. Rowe talks about this 75-day challenge he did with his son, and he accomplished it. But 2 days later, he started drinking again. Okay, so you do go back and you ask the questions and you figure out what the history is. And Dr. A didn't do that. Even in her second report, when she's got this evidence of Mr. Rowe's testimony and Dr. Young's opinion as to how far back the drinking goes, there's no evidence that she investigated that. And Judge Millen, criteria G talks about occupational impairment as well. If you're a high-functioning alcoholic, even if he was suffering PTSD symptoms, he kept working for 14 years. And if you look at what's in evidence,
Okay,
his
Mr.
performance
Gabor.
evaluations, they're excellent. Sorry.
You do an excellent job for your client. We appreciate it. I just wanted to make sure that Judge Christensen had his question answered, and I think he did.
Okay.
All right, then I have a follow-up. I'm sorry. I'm sorry to extend this, but so, and I think you're both right. We can go back and say, you don't have to limit a 30-day evaluation like we do for PTSD, at least under the CAPS 5, for alcoholism or any other mental health disorder that I'm aware of. So, and this kind of piggybacks on Chief Judge Millen's question. You mentioned what Dr. A failed to do, what Dr. Young pointed out that Dr. A failed to do analyzing alcoholism or alcohol abuse. As I understand it, they both experts agree wholeheartedly that Mr. Rowe does in fact suffer from this. Dr. A says it's essentially a consequence of the PTSD, and Dr. Young says no, it predates it. And so this is what I'm struggling with, which is I don't see, and maybe I missed it, but I don't see in Dr. Young's report this going back and asking about how much were you drinking and all this kind of stuff. You pointed out the 75-day challenge. That was just right before he met with Dr. Young. I drank too much in high school. I binge drank at a Halloween party or drank too much at a Halloween party. My doctor told me to stop drinking. I don't have substance, quantity, regularity, frequency, anything about his drinking habits, except in 2007, I started drinking more. Even then, we don't have it from Dr. Young. So how do we get there and say there's foundation for Dr. Young's analysis about alcohol? Dating back, not presently, but dating back.
Well, I think,
Or is
because
that enough?
I think it's enough what's in Dr. Young's report. He goes back and he talks about how far back this drinking goes. And it's not just, we're not just talking about social drinking, going to a Halloween party and having a couple of drinks. It's excessive drinking, and it's not just social drinking, it's every day. Okay, if you take a look at.
But is that in there every day? And that's what I'm saying. Is that in there, or is that in his testimony?
It talks about the frequency of which he's drinking, of which he reports that he's drinking in Dr. Young's report.
All right.
Talks about how many hard alcohol, how many drinks a week, etc.
Any other questions? Thank you very much. Ms. Bierman, I just want to make sure that you get 2 minutes for rebuttal, and I just want to make sure that everyone has their questions answered from you as well. So if you have rebuttal. Okay.
I want to start with just pointing out the fact that there are significant differences between the DSM-5 and the DSM-5-TR. And I point you to the quote that we took from the American Psychological Association or Psychiatric Association, I forget which one it is, that indicates, quote, necessary clarifications to certain diagnostic criteria, unquote, were included in the DSM-5-TR. And those were not found in the DSM-5. So this is a very important part of the DSM that was not at all considered by Dr. Young. I think that's super important to take away. I also want to point out that alcohol use disorder and post-traumatic stress disorder, as the testimony from both experts indicate, they're not mutually exclusive. Actually, frequently, the DSM-5 indicates up to 80% PTSD is diagnosed alongside other conditions. And one of those specific conditions listed by the DSM is substance abuse disorder, i.e. alcohol abuse disorder. Dr. Young spends most of his testimony, when you look through his testimony, I know you already have, he spends a lot of it when he's talking about the alcohol, not talking about specific evidence in the record or from Mr. Rowe, talking about difficulty with alcohol. He's instead talking about this impenetrable fog and how it's difficult generally to parse out post-traumatic stress disorder symptoms from alcohol use disorder symptoms. Well, that doesn't necessarily have to be done here. These things are diagnosed per the DSM together all of the time. If Mr. Rowe meets the criteria for post-traumatic stress disorder, then he meets the criteria for post-traumatic stress disorder. If Dr. Young can't parse through the fog, then it would be my argument and statement that he can't rebut the presumption here. He can't tell whether there's PTSD or there's not. And it is on Dr. Young in this case, because the presumption applies, to show that Mr. Rowe does not have PTSD. That is their burden. And I don't think Dr. Young gets us there.
Judges, any questions? Thank you very much. Your submissions, both sides, were excellent and very helpful, and thank you today.
Thank you.
We are adjourned. We will have this decision out in 90 days.
Good. Thank you all for coming.